Item number 12.
Item number 12, Land Development Code Amendment, Accessory Structures and Uses. A request by the El Paso County Planning and Community Development Department to amend Chapters 1 and 5 of the El Paso County Land Development Code 2019 pertaining to shipping containers, temporary uses, accessory living quarters, agricultural stands, to remove errors and discrepancies and to modify language to resolve recurring issues. The proposed amendments in their entirety are on file with the El Paso County Planning and Community Development Department, LDC 1902. Nina Ruiz. Good morning.
Good morning, Nina Rees with Planning and Community Development for the Accessory Structures and Uses Code Amendment. Mindy Mannon was also part of the team, but she's has other commitments for today, so it's just me. So first, we're going to have Cole Emmons go over the review criteria.
Cole Emmons, County Attorney's Office. The approval criteria is simply the statute that allows you the ability to make changes in your land development code, particularly the zoning side. I'm not going to read this verbatim. I'll try to hit the high points through here. The board may amend the number, shape, boundaries, or area of any district or any regulation of or within such district or any other provisions of the zoning resolution. Any such amendment shall not be made or become effective unless it has been proposed or is first submitted for approval, disapproval, or suggestions from the County Planning Commission. And Nina will indicate in her presentation that that has occurred. If disapproved by the Planning Commission within 30 days of such submission, then the board has the ability to adopt notwithstanding. Before finally submitting to any such amendment, the board shall hold a public hearing thereon. You're doing that this morning. At least 14 days notice of the time, place of the hearing shall be given in at least one publication in a newspaper of general circulation in the county.
So there were quite a few amendments included within this revision. We're only going to cover the major revisions today for the purposes of the presentation. So they have to do with agricultural stands, shipping containers, accessory living quarters, rural home occupation, and then temporary uses. As Cole indicated, the Planning Commission did hear this item last week, and they made a few minor suggestions, and you have those in your packets, and they're the highlighted additional words that are added into the packets. There was a public comment regarding mother-in-law apartments and a concern that limiting the size of the mother-in-law to 1,500 square feet was too great of a constraint. In my presentation, I did provide the Planning Commission with the information that if it functions as most of our houses function, where there's a stairway that goes from the main house into the basement area and it's family that's living there, then it would actually just be considered a dwelling and we wouldn't even consider that a mother-in-law. And it's only where there is no entrance from the main house into the basement area that we would really consider it a mother-in-law, because we allow for as many related people as want to live in a single family dwelling. So the Planning Commission chose not to take that recommendation. They did ultimately make a unanimous recommendation for approval. So first we're going to cover agricultural stands. So in our land development code today, our definition for agricultural stand includes it being made on site. The picture that you see is from an actual agricultural stand in the county where somebody was just stitching little letters into blankets and different items and calling it an ag stand. So we thought, well, we should probably clean this up a little bit so we don't end up with a retail store instead of an agricultural stand. So we're proposing to revise the definition so that it's for the sale of agricultural products raised or grown on the property, to clarify, and then also proposing to add into Table 5-2 an agricultural stand so that it can be an accessory use and not just a principal use. Are there any questions about agricultural stands?
Commissioner Vanderwerf.
Yes, thank you. With regard to agricultural stands, thank you for the presentation.
Is there a lot of violations of this around the county, or is it just kind of a one-off or two-off?
There haven't been. So Mindy Madden, who is part of the team, she's the code enforcement supervisor. So there weren't a lot of violations, but we did have one particular area of the county where there were a couple of stands that were clearly not agricultural stands. We wanted to just resolve it before it became a proliferation.
Thank you.
Any other questions on ag stands? All right, you can proceed.
Okay. So next topic is shipping containers. So shipping containers are becoming much more popular as a storage facility on private properties, so residential, commercial, industrial, all throughout the county. In our code currently, there is no designation of a shipping container. So in our code, if you get a building permit, you can put that shipping container anywhere without there being any kind of restriction. We had brought this topic to you at the work session over the summer and received some feedback about the shipping containers, and that you don't necessarily have a problem with the shipping containers, but you want to make sure that they're screened and that they look nice. So our proposed revisions hopefully address those concerns. So first off, we're adding a definition for shipping containers. So a large metal container typically made of aluminum or steel, designed and built to store and or ship materials. The term shall include, but is not necessarily limited to, intermodal containers, shipping containers, Connex boxes, and cargo containers. The term shall not include semi-truck trailers, mobile or manufactured homes, mobile office trailers, or modular office buildings. In addition, we're proposing to add in temporary shipping containers for when somebody is moving or if they're doing construction on their home, they could have a temporary container on their property. In order to ensure that the containers are safe and that they're screened and don't become a visual nuisance, we're proposing to require the shipping containers to be screened from public view. We're also proposing that they be painted with a compatible paint. So if you have a brown house, you can't put a neon container on your property. It has to look nice. We're also proposing that any shipping container over 200 square feet get site plan and building permit approval. Per Pikes Peak regional building requirements, any structure over 200 square feet is required to get a building permit anyways. We are also proposing that these standards wouldn't apply in A35. So in the A35 zone district, they wouldn't have to screen or paint. For the temporary shipping containers, we're proposing that they can't exceed 30 consecutive days in 1 year. So we don't want somebody to come in saying that it's just temporary, but then they end up having it for years and years. So we thought it was important to put that time limitation on there. And we're also requiring that they're placed on their own personal property. Are there any questions about shipping containers?
Commissioner Gonzalez.
Thank you, Mr. Chair. Just to have a comment, because I just want to clarify, this is not like the county saying we're going from no use of these containers to us approving use of containers. We're trying to regulate because they're already in use and how to make sure that we're not having some poor quality or visual impairment to the residents out there. But we're not approving something new that's not currently already happening. We're actually just trying to make it better.
That is correct. So with our current regulations, we can't really say much of anything about a shipping container other than go get a permit for it. So with these proposed regulations, we would have the ability to ensure that they're properly screened and painted so that there's not as much of a visual impact.
Any other questions about shipping containers? All right, seeing none.
Moving along. So the next topic is accessory living quarters. So right now in the Land Development Code, there are 3 potential accessory living quarter options. You have a mother-in-law apartment, which is attached to the home, and it's for long-term stays of family or employees. You have a guest house, which is short-term stays. It's detached or attached, but not to be used as rental, just short-term stays. And then lastly, we have extended family housing, which is detached from the home, and it's for families when there's some kind of a hardship. So similar to the case that you heard earlier today. What we have discovered is that there's the potential for 3 dwellings with the way that our code is laid out. And it actually could even be worse than that. So for example, in the A35 zone district, you can have a principal dwelling, you can have an additional dwelling unit. Then you can have a mother-in-law apartment attached to each one of those. And then you can have an extended family. So you could end up with 5 houses within the A35 zone district under our current regulations. We've been very lucky that nobody has abused that allowance, but we want to make sure that that doesn't happen in the future. So we're just trying to clarify the regulations and clarify what the intent of the regulations were by putting them into one category. And then we're also proposing some minor revisions to the regulations, and those revisions are based upon the work session and the feedback that we received. So those minor variations will be requiring an affidavit in all cases. So the purpose of the affidavit is to notify future property owners about the limitations that it can't be used as a rental. Our current regulations only say that if you have a kitchen, you have to do the affidavit. So somebody could purchase a property that has something, bedroom, living space, bathroom, everything but a full-blown kitchen, and think they can use it as a rental. Requiring the affidavit will let them know upfront, nope, you can't use this as a rental property. The next one is requiring any variation from the standard to go before the Board of County Commissioners for approval. In the regulations, there's already an allowance for variation from the standards, but because all special uses we can approve administratively, there would be that option for them to be completed administratively. And at the work session, we received feedback that you would like those to come before you. So proposing that from now on, if there are any variations, they're heard before the Board of County Commissioners for approval or denial. And then lastly is putting a cap on the variation of size. Commissioner Gonzalez, you had said specifically that you were okay with there being variation, but you didn't want it to be excessive. So we chose the 20% because that's the same allowance as what we can allow for with administrative relief. So it's a known number already in our code for us to kind of go off of. So that would allow for no greater than 20% of either the size of their home or 1,500 square feet, whichever one is less. Are there any questions about accessory living quarters?
Any questions on accessory living quarters? Nope.
We're almost done. So the next topic is rural home occupations. And first off, I wanted to clarify these are different than residential home occupations. So in our code, we have an allowance for residential home occupations. So it's a very small scale business. So think about somebody that's running an IT business out of their home and they telecommute. This is not a residential home occupation. These regulations have to do with rural home occupations. So it's a larger scale business. But it still is limited in nature to ensure that the impacts to the neighborhood aren't too great. So if we look at the uses that are specifically allowed as rural home occupations, you'll see the very last one is other small businesses which primarily serve an agricultural or ranching clientele. And then if we look under the excluded, we have commercial uses or businesses which do not primarily serve a rural or agricultural clientele. So that seems like it makes sense. But if we look at the uses that are included, it includes contractor's equipment yard, construction business, welding shop. Those people are not going to tell somebody that they can't help them or they can't provide landscaping to their home because they're not within a rural area. It's just not practical for them to limit their clientele that way. So we are proposing to resolve that issue by not limiting them to only serving rural or ranching clienteles, first off. We are also proposing that we add an additional allowance to allow other small businesses that may not be specifically included but meet the intent of this section. It'd be very difficult for us to think of all of the potential businesses that could be a rural home occupation, and our list would just be way too big. So adding in kind of that catch-all we think will help resolve issues in the future. And then one of the specific items that came out of the work session was, Commissioner Gonzalez, you said that you wanted the trucking and hauling business removed because there's the potential for a lot more traffic, and then visually it has a lot more impact. So we're proposing to remove trucking and hauling businesses as well. In our code, we do have some screening requirements, but it only applies in certain cases. So it only applies on parcels less than 35 acres, or if their storage area is greater than 5,000 square feet. It all depends on where they put the items on the visual impact that it may have. So we don't feel like that's really doing the neighborhood any justice if we say that they're limited to 35 acres or 5,000 square feet. So we're proposing to require screening of all outside storage, regardless of the lot size or the amount of storage that's being proposed. A rural home occupation is allowed in the A35 zone district regardless of the lot size. Because the eastern portion of the county wasn't zoned until 1999, we have a lot of lots that are far less than 35 acres out there. So that would mean that you could have a lot that's half an acre in size and you could still run your rural home occupation out of that property as an allowed use. We brought this item up in the work session and we received feedback that you did want to implement a lot size requirement, so we're proposing 35 acres. So that doesn't mean that if they don't have 35 acres, they can't still run that business. It would just mean that they would have to go through a special use process where we could determine if those potential impacts can be mitigated or not. Our current regulations limit the employees by the business. This is difficult because our code enforcement officers can't really go to somebody and say, we want to see all of your employees. Give us records of all of your employees. That's not realistic. So we're proposing to limit the employees to those that report to the property instead of just the total number of employees. That way, if we wanted to count the number of people, we would be able to do that. Are there any questions about rural home occupations?
Commissioner Gonzalez.
Thank you, Mr. Chair. I did also want to clarify. So on the, my concern with the trucking and shipping was twofold. One, traffic, which was brought up, because this would basically allow the contractor equipment yard. My concern was because we had several examples of did this meet or did it not meet the definition of contractor equipment yard versus something that was really more commercial in nature. And I just wanted to make sure that there was something in there that allowed us to not give an open-ended, well, these are all going to be approved, because we had seen in previous examples where they had maybe a Bobcat and a tractor, but then they also had several semis. And so it wasn't necessarily to restrict trucking and shipping, it was to manage the size of these contractor equipment yards, which were not really home, they were real businesses, and that was my concern. And if there was not some sort of limitation, which is why I think we got at the trucking part, because the semis and the dumpster trucks, we'd have no way to restrict it. It would just be a permitted use. And so I just want to make sure that if they also have semis, there's some restriction. They just don't say, well, this is a contractor equipment yard that's approved by use. That is what I'm afraid of. And so I just want to make sure that this is written adequately to restrict somebody coming here from having a bunch of semis and dump trucks and say it's a contractor equipment yard, which would then be a permitted use, and them saying we have no way to restrict them. So that's my concern. I just want to make sure that is adequately written.
So there are several ways within the regulations that impacts are limited and mitigated. So first off, there's the restriction of the amount of area that you can use for storage. So it's limited to 5% or no greater than 1 acre. On top of that, we have a restriction for the number of employees. So if you have a really big, large-scale business, there's no way that you're only going to have a couple employees coming in and out every day, because that's all they'd be doing all day, is just taking their equipment from the home to wherever the job site is. We also limit based on the number of trips. So even if they were trying to abuse it and say, well, we've only got 2 employees, they're going to very quickly exceed their number of trips. And then we're also adding in that if they're going to asked to vary at all from the standards, it has to go before the Board of County Commissioners. So let's say they were saying that they wanted to have 10 greater trips than what's allowed in the code, then that would mean that they're automatically being elevated to a public hearing for approval. So that in itself, a lot of the times will discourage people because it takes a bit longer and then they have to actually present whatever their case is and their justification. But then you as a board would be able to examine and see if you feel comfortable. But if somebody is saying that it's a contractor's equipment yard and they need to have a dump truck as part of their business, then the regulations would not prevent them from doing that. Does that answer your question? Okay.
All right, anything else? How many more do you have there?
This is it.
All right.
Okay. Temporary uses. So currently in the regulations, if there's a T, then it's a temporary use. If there is no T, then it's a variance of use. So even if somebody's just having an event for one day out of the year, we would have to tell them you have to do a variance of use. Variance of use, as you all know, requires the full public process where neighbors are notified and there's 2 hearings, and it's very expensive. So we thought this was a little bit of an issue that we could solve pretty easily. So we're proposing to add into the regulations that the Planning and Community Development Director can approve other non-permanent uses that are not currently identified as a temporary use, as long as they're limited in duration and their impacts are limited as well. Are there any questions?
Any questions? Mr. Dossi.
Mr. Chair, just wanted to highlight for the commissioners that one of the strategic plan goals for our department that was assigned to our department was to constantly try to keep our regulations up to date to address concerns that you have, that we have in applying the regulations. This falls in line with that goal. I just wanted to highlight that for you as we try to keep tabs on where we're at with our strategic plan. Also want to highlight that Mr. Ruiz did a lot of work on this. It may seem like pretty simple stuff, but it affects a lot of people. And to do it in the way that works best, not only for the county, but for the citizens of the county, I think she did that and then some. So a lot of kudos to her in getting through this, primarily because I think I'm usually her biggest obstacle is getting stuff past me. So a lot of kudos to her and appreciation.
Sure, Commissioner Vanderwerf.
Yes, thank you. So with regard to the removal of the trucking and hauling businesses part of the code, kind of akin to a similar question I had asked earlier, did we have a lot of trucking companies and hauling companies that are using these properties? And you know, my understanding of those terms, a trucking company is a company whose purpose is to haul material or equipment or goods from point A to point B. So it's really a transportation company. And then hauling is similar, except it might be hauling trash or agricultural dirt or something like that. And that is different from a contractor's equipment yard where a contractor might be involved in construction, let's say. So do we have a lot of challenges with the trucking and hauling? Were there a lot of companies doing that?
No, we don't. So as part of preparing for this hearing and then also the work session, I went through and I looked at all of the previous special uses that had been approved and what types of uses we were seeing. And since 2014, there have been no trucking and hauling businesses. So it's not like there's a ton of people that are clamoring to get that type of business going. What it would mean moving forward is that they would likely have to go through a variance of use to allow for that type of use on the property.
Okay, great. So removing it this time is probably opportune. It does help prevent heavy use of vehicles on a property. And since there's no known violations of it at this time, this, I think, will help manage those properties a little bit better. Thank you.
Commissioner Gonzalez.
Thank you, and I apologize, but this is why it came up with me, because I understand there's no violations of the trucking. In my mind, there were violations of excessiveness of what was a contractor equipment yard, of companies going beyond what was, in my mind, a contractor equipment yard, because they had similar equipment and vehicles, which you would see in a trucking. And so I think in those examples, I was really the only one who thought that, well, that's fine. But my concern is putting this as an approved use will allow those people who came to us for variances and they were approved, just allow it at use. And this is my concern, is that is going to be abused. And that's my concern. And that was the only way we could do it, was to say something limiting those type of vehicles, which is similar to trucking and shipping, but it was not my intent to limit something that doesn't really happen. We were seeing those type vehicles at the contractor equipment yards, in my mind, which were excessive. So thank you.
So I can show you some of those slides that I had for the work session that show that the screening actually does limit. Could I get the overhead? Okay, so this one is showing before the approval. So these are all violation cases, your favorite. This shows the before, where you can see all of the equipment, and then after you can't see any equipment, so you don't know what's behind there. It could be something that's very residential in nature. I don't know if it'll fit. I guess we don't want any neck pain today, so. So here's another one. This was very, very heavy equipment. This is actually an excavation company. So beforehand, it's a very large piece of property, so it was set back really far from the property. But you can see in the before, you can see an excavator. You can see that there's a semi-trailer. And then afterwards, they actually built some berms up so that when you drive by, it just looks like any single family, or actually agricultural. So this is actually an RV repair company. So beforehand, there were RVs all over the place. So you drove by and it looked like a commercial or industrial site, or even a storage facility. And then afterwards, you can't really see any. You can see one RV. So it could be just like any other home.
All right, I think we get it.
Okay.
Thank you. Any other discussion on these proposed changes? Is there anybody make a comment on these proposed changes? Sir, come down, sign in, state your name, and you may begin.
Good morning. My name is Hunter Hamilton. So my comments are on the shipping container portion of this. And some of the notes I was taking here. So accessory structures over 200 square feet require a permit from regional building, she said. But is a connex a structure? Will building permits require foundations and other non-pertinent items? What additional requirements would be required with a permit? So are you going to have to put a foundation under these? Some other things, a 40-foot container, which are more common than the 20-foot, is 320 square feet. So I would first propose that you change the regulation to cover that. So are 40-footers to be allowed? And then code allows for a 7-foot tall fence, and shipping containers are 8 feet tall. So how are they going to be screened? What are the screening requirements? A fence isn't going to screen a shipping container. So this applies to all shipping containers, even on commercial property. This would require a fence in front of connexes. For me, I'm in an airport overlay zone, which is basically a commercial facility. So why are you going to fence something that's already in a commercial zone? And not only that, connexes themselves are often used as a screening material for contractor yards, is a good example. So my primary concern is there's nothing in here for the GAO, the airport overlay exemption. And those properties are zoned R5 but without residences. So it's essentially a commercial property. They're also zoned R4. So can we get an exemption for the airport overlay district? Because that's going to unduly burden a lot of people at the airport. Also, the building permit process is thousands of dollars on a commercial property. A site plan is thousands of dollars. So is that going to be thousands of dollars per container? Or if you have 5 containers, will all 5 be under the thousands of dollars in expense in permitting to have a container? And, you know, just a general comment about the county in general. People move to the county, people live in the county because they can put a shipping container next to their garage. If they wanted to live in the city where everything's behind a fence, they'd probably live in the city and not have a shipping container. So even though I don't have anything other than rural commercial property, everybody I know out in the county has a shipping container. And they live in the county so that they can have a shipping container. But the GAO, the airport overlay, is a big concern. There are quite a few containers at the airport. Are they going to be grandfathered in? Is there a grandfather process for this? You know, this is to build anything that has a permit and a site plan is unbelievably expensive these days. And when you factor in all of the shipping containers that are in the county, so what's the point of this? If people aren't complaining about it, is it just to generate revenue, or is there a greater good served by a building plan and putting a 7-foot fence around an 8-foot container? That's all. Thank you.
Mr. Pace, Woodman Hills Metro District. I live in Woodman Hills. I express his sentiments, express the same here. It just seems that we have a lot more people looking to control the way we live, where we live, and how we live. And I agree with him. He made a very great point. We live in the country for a reason. The reason we moved out there is for less restrictions and less oversight and less things like that. I also like the fact that a lot of misinformation was being put out there about which commissioner was saying what and what someone believed in, and I'm glad Mr. Gonzalez cleared that up about the trucks and everything. I'm a truck driver, and I've seen a lot of this, and my question is, who was complaining? Was there a line of people standing at the door and going, hey, we don't want this and we don't want that? I like the use of Connex trailers. I don't particularly have one, but I do know this, the standards that those trailers or those Connex units are built by are a whole hell of a lot better than what we have in our building standards because they're welded together, and you can actually stack these things 10 to 20 deep. And people have seen the ships know that. The question I have is, this is about beautification. All I heard was we want to screen it, we want to keep people from seeing it. Why? If people want to buy a property that has a Connex trailer on it, they're going to buy that property whether it has one or not. So when are we going to have less intrusion into the people's lives in El Paso County? I agree that some of the buildings that you had in the pictures up there about having rural people that are owning businesses and using them for that may not be the question. My question would have been, if they're using them for commercial purposes, did they get a permit to operate the business? And if it was granted, then what were they granted to do? Because it is in a rural area on a home site. So were they granted the permission to use their property in commercial purposes? And then if they were, why and how was there a variance granted? As far as the rest of it's concerned, I think that we all ought to start looking at maybe who it is that's asking for these things and why you're asking for them. Just because what somebody may find appealing in their yard, they may not like in somebody else's. It's all up to an opinion, and don't we always have one? All right, that's all. Thanks. Oh, any questions? All right, great.
Is there anybody else in the audience that would like to speak on this matter? All right, seeing none, Ms. Ruiz,
Mr. Chair, I can respond to those comments if you would like.
please.
Okay. So for the comment about building permit, to the point of Mr. Pace, that they actually can get building permits because they are structurally sound. It typically requires them to get an engineer's stamp. We did look into this prior to writing the proposed revisions to ensure that we weren't causing an issue. It would require them to put a foundation to ensure that they're not just in the dirt and will slowly, go down a slope if it gets rainy. There was another point about screening. So the screening doesn't have to be only through a solid privacy fence. Screening could also be achieved through setting it back from the property quite a bit, or it could even be screened by the buildings themselves. So if you're in a commercial area, as was the specific concern about it being in a commercial area, and you have a row of commercial buildings, and then behind there's a service area. If you were to put those connexes in the service area, then they would probably be screened. There was also another point about these connexes being used as a screening mechanism, and that is not an approved screening mechanism in our code, so that would actually require some kind of variance or special allowance to use those.
Commissioner Gonzalez.
Thank you, Mr. Chair. So two things. So you said it could be put on a foundation, but if they're just using it for storage, they don't have to put it on a foundation. You're not mandating that they be on a foundation.
So if they are temporary shipping containers just being used while somebody's doing construction or moving, then there are no requirements. If they are to be permanent, and if they are over 200 square feet, then per the building code requirements, they would need to. And that's even without these proposed regulations. That's just building code.
Okay, thank you for that clarification. And the second aspect, are these changes updates to our rural areas? Because a very specific question about, say either in the airport overlay, but really if they're already in a commercial area that utilizes connexes, are we going to add requirements for screening, or would those not be new requirements for them, or not be, or would they be exempted?
So the proposed revisions don't apply to the 835 zone district as far as screening and painting. They would apply to all other zone districts. So that would include commercial, that would include residential, rural. There was another question about something being grandfathered in. We consider that legal non-conforming. So if there are any that are legally existing today, which means they did get a building permit, because that is what's required, then they would be able to continue on site.
Okay, because I think the gentleman made a good point about if they're already using it like this and we have not enforced a requirement for screening on them in these businesses, I think that does make sense to allow that grandfather.
Yep. And the key is that they would have to be legally established.
All right, any other questions or comments? Could I have a motion, please, to amend chapters 1 and 5 of the El Paso County Land Development Code per the discussion?
So moved.
Is there a second?
I do. I just want to make sure, does that clarify, does that allow administratively for grandfathering of the properties?
So it is an automatic allowance in the code. Okay. So in our code, it says that at the time this code was adopted, anything that was legally established is, we say legal non-conforming, but grandfathered in. Yeah.
Okay, I'll second.
All right, that's been moved and seconded. I'll call the roll. Commissioner Bremer.
Aye.
Commissioner Vanderwerf.
Aye.
Commissioner Williams.
Aye.
Commissioner Gonzalez.
Aye.
The chair votes aye. That passes unanimously. We are going to stand in a brief comfort break.